Hey, good afternoon, everybody. I'm Mike Fielding. I'm a partner in the Food and Agribusiness Unit at Husch Blackwell in Kansas City. And I want to welcome you to our presentation, our webinar today, where we're going to be talking about, making the most of a receiver when you have a distressed borrower. Joining me is Bob Kester, my co-presenter, and we're in for a real treat. Bob has quite a bit of experience in the receivership arena. I'm obviously an attorney. Please don't hold that against me. And we hope to make this a really good one-two punch to make this a very educational and helpful webinar for you. Before we begin, I have a few housekeeping matters that I need to cover, and then we can dive into the meat of the presentation. Excuse me. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them in the question box, and we will try to answer all questions during the webcast today. But if a fuller or more expansive answer is needed, one of us will follow up via email with you after the webinar. A PDF presentation is available in the resource folder. This program has been approved for continuing legal education hours. To report your hours, you will need to click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for your watching and sharing. Toward the end of the program, there will be a survey. Well, frankly, at the end of the program, we will have the survey. And we'd really ask if you could give us your feedback. We really appreciate it. I know I've done several webinars in the past. The comments that have been received have been very helpful. We always try to cater these webinars to really be beneficial to the attendees. And so getting your insight, the needs that you have, it's really helpful so we can try to custom tailor things that are helpful in the future. That's all that we have as far as housekeeping matters, so we can dive into things. As I indicated, Bob Kester is joining me today. Bob is the founder and owner of Bob Kester Business Financial Services, where he advises clients on ways to manage cash flow and to improve net profit. And as I indicated earlier, he has quite a bit of experience dealing with receiverships. I deal with distressed loans. What I do is help lenders deal with really tough, difficult situations and, frankly, find solutions, ways to get out of it in an effective, efficient manner. So with that, let's get started. To begin, we've got really two big agenda items that we want to cover. We want to go through the nuts and bolts of receivers, and then we want to do a deep dive into some key receivership issues. And we do this really to set the stage, the platform, the beginning, the foundation, so to speak, in part one. And then part two, we'll dive into some of the more, I don't know if you want to say tricky issues, but more difficult issues that will arise when you are dealing with a receivership. So with that, where we begin is with some basic understanding of general receivers versus limited receivers. And this is a really important distinction because whether you have a general receiver or a limited receiver is going to impact compensation type issues, what the receiver will actually do, what the borrower will do or cannot do. And so understanding that is important. So a general receiver, as the name implies, is somebody or some entity that is set over all of the borrower's assets. Typically, when you think of a receivership, it's going to be for a corporation or for an LLC. It is possible to have a receivership for an individual, albeit that type of receivership would be for certain specific assets that would be subject to the lender's collateral. General receivers have really broad powers. Some states, such as Missouri, have very specific, very detailed receivership statutes. Other states, Kansas is an example, have, I think, just 5 pretty bare bones sections dealing with receivership statutes. And so the powers will really vary from state to state. It gets into the receivership order that we'll talk about. But as a general matter, a general receiver is going to really be vested with management, operational authority to deal with the business. And a good way to think about the receivers, treating them as like, or considering them like a Chapter 7 or Chapter 11 trustee, what you would get in bankruptcy, although it's a little bit different. Now, limited receivers, on the other hand, are a little bit different. As the name implies, they have limited powers. Their limited powers will be delineated or focused on specific or discrete assets or types of assets or types of issues. And then beyond that, the borrower will control the other assets in the business enterprise. The powers granted to limited receivers have to be very specifically delineated in the order that sets it out. Bob, tell us about benefits of a receivership. Why on earth would anybody want to have one?
Well, first of all, good afternoon, everyone. It's my pleasure to be here joining you this afternoon, and I hope whatever I have to say is a benefit to you. Been at this kind of stuff a long time, so I'm happy to share what I've learned over the years. One of the first benefits, I don't read slides, so the idea of flexibility is a receiver can really get in and operate the business more along with our title of maximizing recovery or minimizing loss, can make some operating decisions, can make some discretionary expense decisions, many of which have not been made by the, in most cases, defaulting owner, to keep the business operating much more professionally. The receiver clearly is between the asset and the bank. That works to the creditor's advantage because the receiver really can tell the debtor, get out of the way. You know, I'm going to report, I have to report this to the bank. And in short, what you're saying is, I really don't care whether you like it or not, because this is what has to be done. So there should be a level of trust that builds up between the receiver and the secured creditor, who typically picks the receiver. My experience has been that having a receiver who's got a really good background in special assets is really beneficial. There are a lot of things that happen to a loan officer that focuses on special assets that probably don't always or as frequently happen to a line lender, that really help when you get thrust into one of these receivership roles. A guy in special assets probably has a lot more experience and in-depth experience with Article 9 transactions and some of the other nuts and bolts kinds of things that inevitably come up in a receivership situation. And of course, there's a lot more one-on-one reporting, not being a trustee or having an unsecured creditors committee to report to necessarily. Just actually, it takes what can be an uneven process and really tries to level it out and make it run more smoothly. So, Mike?
All right. So let's talk about the risks of a receivership. And we have a bit of a checkerboard up here on the screen, and need to touch on these briefly. The language is self-explanatory, but needs to just briefly touch on each one. The idea of costs getting out of hand, that is it's taking a nightmare and making it even worse, right? You have a bad loan, you're trying to get out of this situation, and then the collection costs, receivership costs go through the roof. That's obviously a bad scenario. We'll talk about how you can try to control for that or mitigate that in a little bit later on in the presentation. Another bad situation is if you have a receiver who gets appointed by the lender and then suddenly turns on the lender and goes rogue against the lender. That obviously is not something that you want, right? You went out, you handpicked this person to really try to help the bank. And if the person then turns on you, it feels like a bit of a traitor. So you want to hedge or take protective measures, particularly in your order of appointment, to protect against scenarios like that. One big practical problem that you run into is inexperienced judges. Receivership actions are not the most common type of judicial proceeding. They certainly happen every year, month to month, but there's a lot of judges out there that have had very limited to no experience. And the challenge with that is you'll have some judges that get it, they'll just go along with it. The other issue is sometimes you'll get judges who really don't get it. They maybe have a real bend towards the borrower, and that's a risk that you may run. There's no automatic. Yeah, go ahead, Bob.
Can I jump in on that for just a minute? I was asked to be appointed. I don't know my Missouri counties as well as I ought to, but whatever county Chillicothe is in, we went all the way up there for the order or for the hearing to appoint the receiver. And literally, the judge was reading a definition of a receivership while he was deciding the previous case, which was a sentencing hearing for a DWI guy. So, I mean, we didn't get our receiver, and it was, as Mike has said, it was a small town, and it wasn't going to happen for any one of a dozen reasons.
Yeah, and hearing that, Bob, I remember I had a few years ago a situation. I was representing not the secured lender who got a receiver, another lender had pursued after that, but we go into federal court, right? In the exact same scenario, there was it was a criminal matter, sentencing. We were all there, all the parties on this receivership were there for a pretty contentious issue. And the judge basically just said, I'm going to take up this criminal proceeding. So we sat there forever, and then he gave us less than an hour to really argue everything. It just felt very given the short elbow. So that's the risk you have, the issues that you have getting into court. You get these the lack of experience, and frankly, sometimes a bit of a lack of concern because the judges they just view it as a commercial matter. So again, we're just trying to put the risks that are out there. It doesn't mean you don't go with the receivership. You just basically want to identify the risk and try to hedge against it. Now, other issues, just briefly moving on, you don't get nationwide jurisdiction like you do if there's a bankruptcy filing. It's going to be limited to where you're at, and then you'll be trying to get courts to recognize the order if you have to go to other jurisdictions. There's actually very little case law out there, relatively little case law on receiverships, because most of these matters are handled at the trial court level. It's pretty rare that something actually gets appealed. And so, that sometimes is really good or sometimes can be bad, right? The lack of precedence gives you a lot of leeway and flexibility to be creative, to do things, which is a plus. The downside is if you get into a really contentious situation, the lack of judicial clarity or guidance or decisions can leave some real big unanswered questions as to how a court would rule. A receivership is not a bulletproof remedy against bankruptcy, especially if you have like a person who's an individual. I think there's a pretty good constitutional argument that you can't divest a person of the constitutional right to file a receivership. However, especially if you get into like a forbearance type situation, you may be able to put a forbearance agreement provision in there that would essentially provide and also put it in the receivership order that if it's like an LLC or a corporation, that they would agree not to file for bankruptcy. So you might be able to hedge against that. Is it 100% bulletproof? No, but it's certainly some helpful language that may prove to work for you. And then finally, the big issue is on a receivership, do you have an uncooperative borrower, right? There's nothing worse than you get a new captain appointed for the boat, and then the former boat owner, so to speak, is out there trying to sink it. And that definitely happens as well. Bob? And
that's a real good lead into examples of where a receiver is ideal. I looked up the legal definition of incompetent this morning just to double check, and what I've found is uncooperative and inept may almost be synonymous as going into a receivership. I would say inept owner-operators are really more the case than technically incompetent. They might be able to do a lot of things. Running a business isn't one of them. Properties that are environmentally suspect. One experience I've had has allowed me to go in back to the lender and insist on a phase 2 environmental audit when all they had previously agreed to was a phase 1, because phase 1 doesn't really tell you much. But the lender because it was me suggesting, or any other receiver for that matter, suggesting that they needed to go to a more aggressive step, and was able to show them why they needed to take a more aggressive step. Actually ended up saving them some money in the long run, because they'd had to do a phase 2 anyway. And then they discovered what their potential environmental liability was much earlier, and could make some other operating decisions along that line. Fraud, misappropriation, and conversion might as well be the ABCs of a defaulting obligor. It's just, if it isn't 1, 2, or 3, it's 1 and 2, and 2 and 3 are all of them. I mean, it's like the Pythagorean theorem for making sure the deck you hang on the back of your house is square. This stuff is all going to happen. Assets disappear all the time. One of my favorite accounting terms for is, well, we put that over into. This usually comes up when you got a bunch of little shell companies, and there are all kinds of swap out entries to hide the really deteriorating financial condition. Assets get wasted right and left. It's just amazing how stuff disappears and gets consumed. There's always the risk that the collateral is going to go south when you least want it to. A good example, a number of years ago in Johnson County, was a lender financed the acquisition of a rather large herd of Arabian horses. And the problem was the Arabian Horse Association didn't recognize these particular bloodlines. But what the horses were really being used for was they were being surgically implemented with drugs. And they were shipped into the country. And then once they came out of animal quarantine, they were opened back up so that the drugs could be distributed and sold on the open market. And then the animals were allowed to waste. And basically, by the time the FDIC had their auction, they were just bags of bones. Corporate dissolution or deadlock. This comes up every now and then. I would say deadlock is probably a bigger problem, in that when it comes time to dissolve the company, the two owners can't get along. And one of them thinks they each think they have the upper hand. But sometimes it's a great idea to get a receiver in there and sort out who really has what, and then help support the case for whichever way is the correct way to go.
It's a good point. Now, Bob, we had a question come in. I think it's good to pause and just ask this. The question was raised: are there occasions when the special assets manager is able to act as a receiver? I love the creativity of the person asking the question. And I'll just say, from a legal perspective, I have never heard of that happening. Could it happen? Yes, I think theoretically it could. I think the big practical roadblock that you would have to that is a situation where, people would say there's a conflict of interest, right? Because you would have the lender with the loan, and then wanting to appoint a special assets manager who's also on the lender's, payroll, to try to act and steer things for the bank. Go ahead, Bob.
I think the department manager in that case would have to conflict out of that. There are way too many problems. It's been overblown in the past, but one of the first that comes to my mind as an answer to that question is lender liability. It's going to be really hard to make decisions that are even and not lopsided towards your boss. That's just human nature. So I wouldn't, if I were a lending officer in a special assets department, I wouldn't take one. If I were the department head, I wouldn't allow it.
Yeah, I think on the lender liability, I guess let's just pause here for everyone, because I think that's a really good point. The point of a receiver oftentimes is, the borrower can't be trusted for whatever reason. We need somebody else in there, but we want to use the receivership order and the existing legal framework to essentially box that receiver in, right? There should be a very specific delineated set of functions, kind of a clear mission that the receiver is going to accomplish. And then you create the appropriate boundaries to try to hedge against, like we said, a rogue receiver or somebody going outside the boundaries of a budget or something of that nature. When you do that, when you box the receiver, with sufficient latitude, but within certain well-defined parameters, what ends up happening is it actually creates a bit of a buffer for lender liability between the receiver and the bank, because the bank is, on the one hand, it's the lender, it's doing its thing, but the receiver is the person that's been appointed to make the decisions to liquidate the collateral. The receiver will have to post a bond that we'll talk about in a second. But that insulation from lender liability can be a real protection for the bank as well. All right, so let's talk about a few examples where a receiver would not be ideal. Multi-state property locations can be really problematic because you would get a receiver appointed in state A, and it may be possible to go to state B to foreclose or liquidate or sell. And you may run into issues about courts there recognizing it. Is it impossible? No, you could certainly do it, but it just creates several additional headaches that you're dealing with.
You're gonna love this example. One of the very, very first problem loan special asset cases I did involved a bunch of mining and construction equipment that was in Southeast Kentucky. Well, it was so far in Southeast Kentucky that the southern border of the Kentuckian county shared the northern border of the corresponding county in Tennessee. So the debtor had taken a couple of pieces of machinery to a repair shop that was located on the Kentucky side of that border, didn't pay the bill. The lender or the repairman moved the equipment to the backside of his property, which was actually in Tennessee. We had perfected our liens in Kentucky, but our perfected liens in Kentucky were primed by a mechanic's lien in Tennessee because he came ahead of our perfected UCC filing. As far as I know, that machinery is still there.
Shows you the headaches of dealing with the multi-state issues. And
yep.
You got to say hats off to the repairman, right? I guess that's the benefit of living on the border. You can take advantage of
really.
it. Yeah. Some other situations where receiverships don't work is where you have an assignment for the benefit of creditors. That's kind of like a cross between a Chapter 7 trustee. It's out of bankruptcy, but you've had this asset assigned where you get the assets to be liquidated. Another one is if sometimes the loan is too small, right? It's just too costly, too expensive to bring a receiver in. And there may be times when the appointment of a receiver may not be the optimal thing. The better thing may be to monitor this, get a court-appointed monitor for the situation. Bob, any further thoughts on that?
Yeah, I do. Just really quickly, assignment for benefit of creditors are very, very seldom seen around here, but they're really popular in Illinois. In fact, there are firms in Chicago particularly that do nothing but serve as holders of assignments for the benefit of creditors, and they've got a lot of rights that you can't get around. The monitor idea is intriguing, particularly if the lender thinks that there might be a legitimate way out, and what they really need to do is get a good understanding of where the cash is, where it's been, and where it's going, and what the collection policies and procedures are like. You can get a monitor appointed for specific purposes with typically, at least in my experience, with the understanding that if there's any aberrant behavior, the monitor relationship can be overnight converted to a receivership.
Yep. All right, so in the interest of time, let's move on. If you're going to get a receiver appointed, it's important to understand that there's really 3 separate grounds to get the receiver appointed. Sometimes they kind of merge, but legally it does make a difference. You have contractual, statutory, and common law. And what I mean by contractual is virtually all loan documents tend to have language that allow for the appointment of a receiver. And that can be really important because some judges will put a lot of weight on that. You may have a loan that's in default, but you may not have kind of some of the other grounds, like for injunctive type relief, like, the fraud or the wasting of assets. And some judges will say, listen, the borrower signed this. He or she agreed to the appointment of a receiver in the event of a default. And so that contractual remedy is really important, because you want to say, this is what they agreed to. This is what they admitted to or conceded to doing. There's statutory grounds in some states. Typically, those grounds are going to mirror the common law, the equitable type grounds, which again is going to be fraud, wasting of assets, a real need to get somebody that's a third party that's in there. Now, what we've done here is just did a listing of assets, and you can look at what state you're in, or what state, your borrower is in, I should say more importantly. And you can see that on the left-hand side of the screen, if you're in these states, Arizona, Missouri, Tennessee, Texas, or Utah, there's a pretty good, a pretty well delineated, well spelled out receivership statute. The flip side is, if you get into the states on the right-hand side of the screen, the receivership statutes are pretty vague. And that goes to a point that I made earlier, which is you can get really creative with the order. You've got a lot of leeway with what you can do. The flip side is, if you're in a state with a robust statutory scheme, like example, Missouri, then a lot of that's going to already be spelled out. Now, it's important to keep in mind that receiverships are not just limited to state court. Federal court is also a great place to proceed to get a receiver if you want. There's a federal rule of civil procedure that directs the court to frankly consider the local practice. The standards for appointing a receiver in federal court are going to be similar to seeking an injunction. I'll say also the contractual grounds would certainly be applicable also. The receivership order is going to be the really big important thing that you get there. And, frankly, this gets into how do you get the receiver appointed. If you can, in an ideal world, you will negotiate with your borrower up front and get them to voluntarily agree to the appointment of a receiver. And if that's the case, you go in, you have your order negotiated. The judges tend to typically just rubber stamp it and appoint it. It gets a little bit more dicey if the borrower is opposing you. There are some federal statutes out there for receiverships, talking about sales of property and things of that nature. So the good news is you can go state or federal. And, the question is, when would you want to go state versus federal? It's kind of the age-old question. When would you prefer to get into federal court versus state court? Well, I think there's a general belief among, certainly on the lender side of the equation, that if you have federal jurisdiction somehow, the federal courts tend to be more structured, more predictable, more organized. I think the flip side is, if you're in state court, you can get, I don't want to use the word abuse, but a lot of non-lawyers would say, yeah, it is abusing the system, where they stretch things out inordinately long. You get a lot more unpredictability with your judges in the state court. All right. So now we're going to play a game of checkers, so to speak. Receivership order. I've mentioned this several times. The question is, what do you do with the receivership orders? The next thing we want to do is look at this and really go through some of these key provisions. Some of these are pretty obvious. Why would you want to have grounds or reasons for an appointment of a receiver? You need to establish the judicial basis for the appointment of the receiver. If there's a contractual grounds, you want your order to recite it. If there's been defaults under the loans, you want to have that in there if at all possible. It's really critical that your receivership order delineate very clearly what property is subject to that receivership. Mm-hmm. Again, think about a box, right? We want to know everything that's going to be in the box, and these boundaries on the box are really the rules, the parameters that are going to guide and delineate what's going to happen. The budget is a really big issue, and I know we have another slide coming up, so I'll skip over that, but the budget issues are super, super important. We'll talk about that in a bit. Compensation, obviously, the receiver is not going to work for free. It's really good practice to have a discussion up front with the receiver. How are they going to be compensated? Who's going to foot the bill? And what happens if you run over the budget? Those are important discussions that you as the lender want to have with your receiver ahead of time. Will the receiver be hiring an attorney to represent it? That's an important question. Who's going to pay for that? You need to have these discussions up front so that there are no surprises on the back end.
I've normally found that those conversations are typically a couple of hours in terms of just fleshing out what's going to go into the order, so that there are no questions. Because Mike, I think you'd agree, there aren't very many judges that like surprises.
Right. And, from the bank's perspective too, I mean, you've got a loan that's on non-accrual, you have to do your reports. The question is, what are we ultimately going to get out of this? You want some predictability as well from a loan, from SAG or from special assets, and so you want to report it. So getting those boundaries are really critical. There's interesting issues. Can the receiver borrow money? Maybe, right? And then you get into the whole lien priming issue, or is there unencumbered collateral that can be used? You get into kind of these standard, similar bankruptcy type provisions, the ability to sell or lease property or reject leases. If you get into robust statutory schemes like Missouri, there's already provisions that are spelled out there. The flip side is other states where you don't have this robust scheme, it's really vague, and you got to build that into your order. Indemnification issues are important. Some receivers will maybe try to incorporate that. That's a big issue for the bank. The bank's response would be, well, that's why we have a bond, is to protect there. So those are discussions that need to happen as well. We've talked about the professionals, the ability to use permits, especially if you have a receivership that is dealing with any sort of regulated industry. What do you do if the receiver takes possession of the property and there's alcohol? Well, that's an issue. Or firearms, that's another issue. Or maybe there's some sort of controlled chemical, that's another issue. You need to look at these issues and think through how it's going to be handled down the road. Bob, other thoughts that you have on the receivership order?
Yeah. On the order itself, let's talk about a couple real quickly. The permits and licenses are really, really important, because even though it might be very, very clear that the receiver has control over the property, depending on what the property is, it may or may not be easy to dispose of. For example, several years ago, while not as a receiver, but as a monitor, I was asked to liquidate 16,000 square feet of fireworks. Well, I mean, that by itself was okay, but because of the licensing requirements, the best way, well, let me back up. The best way to dispose of the assets were to sell as many big pieces as we could, rather than a bag here, a bag there. That said to us, well, we have to find another wholesaler. Well, that in itself was fairly easy, but then we had to go through the whole licensing procedure for these wholesalers to not only acquire these fireworks, but to transport them from our site to theirs. And it got pretty complicated. I want to focus on indemnification and the bottom right square of the checkerboard. This is very, very important. For the attorneys out there, I learned the very, very hard way that the IRS can deem a receiver to be a fiduciary. And if they do, as the receiver, you had best have filed IRS Form 56, establishing yourself as a fiduciary by definition. And here's why. If you don't, regardless of whatever other arrangements you've made for payroll, if you don't, you can be held personally liable for unpaid payroll taxes. Let me repeat. If you do not file this Form 56, you may be held personally liable for unpaid payroll taxes. It happened to me. And it's not fun. Because my remedy, and this goes back to indemnification, my remedy was, even though the order was very, very clear about me as the receiver having no tax liability to any taxing authority of any name, shape, way, or kind, the IRS said, nah, that doesn't apply to us. So that put me in the position of, well, what could I do? And the IRS's answer was real simple. Go sue the judge that signed the order. So let me ask my attorney friends out there this question. Can any of you name an attorney anywhere in the greater Kansas City metropolitan area that's going to file suit against a Clay County judge?
It's not going to happen.
Don't see that happening. That's an important point, friends. Pay it. Look at it yourselves and be sure that you understand it when you're advising your clients or you're contemplating getting into a receivership situation. It can be very expensive.
Yeah, and that's a good point, Bob. I think just listening to you, I'm reminded of there's the federal government under the federal statute has it's the federal super priority statute when it comes to insolvent entities. And as you can well imagine, the federal government says we come first, no matter what. And the exceptions are if you have a bona fide lien of a lender, that's going to trump. And if you have a bankruptcy proceeding, that works, or there's a carve out for insolvent insurance carriers, the receiver. And so doing what Bob is saying is absolutely critical to protect the receiver. And as a practical matter, the receiver, once appointed, is going to have to stay current on payroll taxes and do those things. Now, that doesn't mean that he has to cure past defaults that occurred under old management as long as you get the receiver appointed. But that's a really important thing you want to be looking out for. So moving on here, what are some risks of a receivership order? There's some, and Bob actually touched on this with his example. There's limited case law, obviously, so you don't have a lot of precedents, but sometimes you may have a situation where the receivership order says ABC, whatever it may be, and that feels really good and comforting. The problem is it may be unenforceable or it may contravene existing law. And that's where you get into this issue of a judge has said this, but then you have some statute or something that's going to collide with it. I think a great example, borrowing in the agricultural space, right, is when you get into like assignment of government payments, right? Secured lenders, they'll get their normal UCC, they'll get the assignment of payment intangibles or general intangibles. So when the government monies come to be paid, you think, well, I should get it from the federal government. Well, the problem is the federal government just ignores state law and UCC secured creditors, and the only way they're going to send those monies to a bank is if the borrower has signed there's a particular form that has to be signed with the FSA office. I draw that as an analogy to say that you want to be, it's good to have expansive orders, it's good to be creative, but just don't be so creative that you think that order is 100% bulletproof. So you want to act within realm of reasonableness there. Let's talk about bonds. Receivership bonds will almost always required. Theoretically, I guess you could get a receiver appointed without a bond, but I honestly can't think of a situation when that hasn't occurred.
I can't either.
Yeah, the big issue for the bank is what's the bond amount and who's going to pay it. A lot of times you'll get the bond cost advanced against the loan, which is an appropriate option. I think the really big issue for the bank is how much is the bond going to be? And this can actually be a big fight with the borrower and the bank. The bank may have a lot of trust in the receiver. The bank may be willing to put the bond amount lower. The borrower, on the other hand, may say, well, that's my business. I've worked hard. I'm worried about this person sinking it. And so I want a much larger bond amount. And so that potentially could be a point of conflict between the two. Bob, what are your thoughts on bond issues with receiverships? It's an important issue.
Yeah, it is an important issue. And I've never done one where a bond was not required. Typically, either the lender or the lender's law firm has paid the premium for the bond. And I say that because typically, unless you're a very large company that does little else but receiver type work. For example, I, as an individual, I'm not bondable. It requires so much personal wealth to be able to pass muster for a bonding company that they're very, very difficult for an individual to obtain. Doesn't mean the receivers are bad guys. It just means that the underwriting standards for bonds are set at such a high bar that it requires a substantial entity to be able to qualify for them. So as you're looking at the lenders out there, as you're talking about receivers, yeah, you're probably going to have to pay the bond premium. And yeah, there's probably going to be an argument about how much the bond should be. And at some point, you're going to have to get the debtor you and the debtor are going to have to agree to some amount that you can both live with. Now, whether the right amount is high or low, I think it really depends on the complexity of the case. If it's a single asset case, and the income streams are easy to identify, maybe it can tend toward the lower side. If there are a lot of moving parts, it's going to require a higher bond with a resulting higher premium.
Yeah, and that's the give and take. And so somebody may be saying, well, what's the low side? And I know in Missouri, there's been situations where banks have gotten away with $10,000 bonds, right? And you're like, holy cow, that's really low, but it definitely happens. And if you as a bank are fine with that, you have a lot of trust, your collateral is really good, that may be the way to go to keep it on the really low side. The problem is you may go into court and everybody may agree on it and you get the wild card of the judge. And I think that's the issue. There's no really good statutory or case law guidance as to what an appropriate bond amount is. It's really dependent on the circumstances of the particular case. All right, budgets, another really big issue, really important budget. So the issue is going to be who's going to establish it, what happens if the budget is exceeded. Let me tell you, for people that are contemplating something in Missouri, because this gets into budgets and who pays for the receivership, the Missouri commercial receivership statute says if you as the bank move ahead and get the appointment of a receiver, then your recovery on your assets are subordinate to administrative expense claims. And that's kind of a scary thought if your administrative expense claims get out of hand. And so you want to really contain those costs, those expenses, so they don't eat into your collateral. The worst case scenario is where you have a receivership that just gets run amok and you have all these administrative expense claims being incurred and that could potentially chew into the collateral. There's a case pending out in St. Louis right now where there's an interesting scenario where it was actually the borrower of all people. It's kind of a crazy scenario, but the borrower in the Vatterott College matter moved for the appointment of a receiver. And in that case, I don't know if it's been concluded. I know it's drug on for at least a couple of years. And one of the issues was, could the administrative expense claims be surcharged to the bank? And the court, as I understand it, ended up ruling saying no, because the bank didn't move for the appointment of a receiver. So the bank dodged a really big bullet there. Most of the time, though, it's the bank that's actually moving for the appointment of the receiver, so that it's going to fall on your shoulders. So when you get into this, it's really critical that you as a bank have some pretty some really clear discussions with the receiver about what the budget is going to be, and then have very clear parameters about what happens if the budget is exceeded. It's common that you may have like a 5% or maybe even a 10% leeway on the budget because there's unexpected issues that come up. We get that. But you need to have some checks in place, or safety measures, safety valves, so that if something really unexpected comes in, that it can be dealt with. Bob, what are your thoughts on budgets?
Yeah, let's use a specific example. Suppose you have a single asset case like an apartment complex. It's pretty easy to come up with a working budget because you more or less know what utilities are going to be. You more or less, you know what the taxes are going to be. You know what the insurance is going to be. You know pretty much what the people costs are going to be. But you can't budget for things like a water heater blowing up at 5 o'clock on a Friday night. So if you haven't negotiated some ability to be flexible for on-the-spot needs, it's pretty easy to blow the budget up. The other part of that, or another part of that, is it's helpful if your receiver candidate has a pretty good knowledge of the industry that you're asking them to be appointed receiver into. For example, if Mike were to ask me about a trucking company, I'd say, sure, I've done plenty of that, and I'd be happy to do that for you. If his client said, well, we've got a grain silo operator or an elevator operator, I don't know that industry. So I know that I could be lied to right and left and not know I was being lied to. So those are some of the things that you have to consider in this budgetary process right from the very beginning.
Good point. I think another thing too, Bob, to think about too is when you're contemplating the receiver, you need a lender should ask, what's the overhead that the receiver brings with him or her? If you're bringing somebody like Bob on, a sole operator, not going to have the overhead. There's some other companies out there that hold themselves out as kind of professional receivers, but they have a lot of overhead and a lot higher expenses. So you'll want to tailor it to your situation to get the right fit, but certainly you always need those budgets in place.
Well, I just to take that a quick step further, I have nothing against big receiver companies, but they're in business to make money too, and the orders that I've been subject to have always stipulated my charge. Have always, if I plan to hire an attorney, I will name that attorney and get a billing rate from them. And then things like administrative people, I plug it at an hourly rate, and I don't mark them up. So the cost, as nearly as can be told from the outset, the basically fixed or known costs are pretty clearly established right from the beginning.
Yep. Well, we're about down to 10 minutes, so we got to pick up the pace here a little bit. So we'll go through some of these slides a little more quickly. Receivership borrowings, I touched on this earlier. The slide really speaks for itself. That's the big question. Are you going to be incurring new debt? And is there unencumbered collateral that's out there? I know lenders never like to be primed, but sometimes you may have to do that. And if you are getting a priming lien, you'd want to put some real boundaries on that, because there's certainly times when a receiver may need some legitimate capital to operate. So again, you think through those issues. Receivership sale. Go ahead, Bob. Go ahead.
You need to understand that just because the order gives the receiver the right to borrow and instructs the lender to honor the receiver's right to borrow, doesn't mean the lender has to do it.
Very good.
A receiver loan is a priority payment obligation. But what led to my problem resulting in the Form 56 checkerboard square a little while ago was specifically that the lender refused to make receiver loans. So
that's the issue you get into. All right, so receivership sales are important, right? The big issue is a lot of times you've appointed the receiver with the goal or the hope of selling the business unit as a going concern. The problem is frequently it's not just a single lender situation. There may be a PMSI lender that's out there. There might be some tax liens. There may be some subordinate lien holders. And so one of the questions that you run into is whether or not you can get a sale allowing the assets to be sold free and clear of all liens and encumbrances. And that's a really interesting issue. The short legal answer is there are some arguments out there that say, yes, you can. I think the real kicker is if you can get a court order that says the sale is free and clear and it provides for liens to attach to sales proceeds in the respective order of priority, most courts will probably uphold that and let it go through. So that is the good comfort. You can sell as kind of a going concern. There's other considerations, though, that you need to bring in there. How's the receiver going to liquidate the assets? Public sale, private sale, that's really important. It's going to impact the dollar amount. Again, this is one of the issues when you're having these discussions at the forefront of the relation or at the beginning of the engagement, that you want to work that through with the receiver. The reason that's important is because you get into, your commercial reasonableness, business judgment standards, and you want to make sure that the receiver's protected, but also that the bank can't be accused of, selling assets for less than something that's commercially reasonable. You get into the other issues down below, title issues, receiver's deed. Does the right of redemption remain? It depends on who's controlling the property. Bob, any other thoughts on receivership before we move on?
As far as commercial reasonableness goes, that's always to me the best test to apply. And I've usually found that whether the borrower or the lender or not like it or not, auctions are the way to establish commercial reasonableness. You get two people, you got a sale, and if you insist that it be a no reserve sale, then there's no doubt that when the gavel goes down, the property's sold. Yep.
And especially if you're using like a third party, there's various companies out there, Ritchie Brothers, Big Iron, anyway, other groups out there that'll liquidate it. Yeah, a lot of real estate companies, cattle companies, depending on what you're dealing with. Going through the third parties is always helpful because they've got the network for advertising. So what are some objections that you'll get? Well, the big one is that cause doesn't exist. And the borrower, especially if it's a small business, doesn't like this feeling of being kicked out of their house, so to speak, right? Nobody likes that feeling. And so they may really push back. They may argue that, there's been a breach of the contract. However, I still should remain in possession of the property. I know years ago I dealt with that issue in Jackson County, Missouri, of all places, and the judge had a real issue with it. We contractually had a ground for the appointment of a receiver. We went in. There was a default, and the judge just was like, it's payment default. I don't care. I'm not going to appoint the receiver. Very frustrating situation. He did issue things that helped us proceed forward ultimately with the liquidation of the property, so it turned out good in the end. But that's the issue, the challenge that you run into. You put in this time, this effort, and then you may get a judge that says, no, don't like it. So does that always happen? No, there's a lot of judges that will appoint the receiver. It's just a risk out there that you need to be aware of. Another issue is if there are issues of like lender liability, when you file that receivership, and if your borrower is really adverse against you, they will maybe counterclaim as a defensive measure to try to stop the appointment of the receiver. Bob, what are your thoughts on making the most of a receivership?
Well, obviously the borrower needs to approve it, and that's going to be a little bit of a hassle or good negotiating. Budget accountability is very, very important, because keep in mind that the goal of this whole exercise is to maximize recovery or minimize loss. But this third one, here's what's going to happen. The debtor is going to pretend that they don't understand the main role of the receivership. They're going to say, yeah, they do, but what they're really saying to themselves is, this is a draconian remedy, and I'm not for it. And you guys are taking my lifeblood away from me, and I don't understand why you need to do this in the first place. And somewhere along there, you have to say, well, if you weren't 8 months behind in your payments, we might not be having this conversation. So just know that those kinds of conversations are going to happen.
Yeah, and that's just part of the situation. Now, related to that, this builds on the duration and termination of the receiver. I think, again, I like the box analogy, right? We're starting at a beginning point. There has to be an end. And what are those milestones? It may be liquidating certain pieces of collateral. That might be the big issue. And once that's liquidated, you want to terminate, discharge the receiver. There may be a certain time duration. It's going to really depend on your situation. But having clear milestones, especially if it can be laid out in the receivership order, is helpful, because it creates a sense of predictability for everybody. And oftentimes, if you have more predictability, more clarity, that's going to help keep your costs down. Compensation, we've talked about that. You have to have provisions in there of what if you get a subordinate lien holder who suddenly becomes incredibly adversarial, and suddenly what you thought was going to be a 6-month case is now turned into a 12-month or 18-month case. Well, that's a problem, and you need to kind of have those contingencies in place. It helps if it's operating as a going concern, that there could maybe be revenues to that would be used to pay the receiver as an ongoing concern while the collateral is attempted to be liquidated. And then obviously you've got to deal with subordinate claims as well. Brief issue on, oh, go ahead, Bob.
Yeah, just real quick. What I always try to do is establish under normal circumstances what a reasonable cash to cash cycle would be. So if under normal circumstances, if it's a 90-day conversion from raw materials to finished goods, and then another 40 to 5 days to collection, then that's going to help me define my cash to cash cycle. And that's going to help me build milestones for finishing work in process, getting it out the door, getting it shipped, getting it paid for, clearing the delivery and acceptance hurdles, and getting the money coming back in.
Yeah, good points. We've had several questions come in. I want to touch on those. Let me touch on receiverships and bankruptcy, and then I want to get to the additional questions that have been raised while the few minutes we have. The risk you run when you get a receiver is the borrower may run out and try to file a bankruptcy. Even if you have a provision in there saying, the receiver controls the corporation, and the corporation can only be filed for bankruptcy by the borrower, by the receiver. The code has an exception to where the receiver may be excused from turning over property. If the case is really advanced and there's like a last-ditch effort, you may be able to get it to where the bankruptcy court would allow the receiver to continue in place, or maybe even dismiss the bankruptcy, and then the receiver is going to get their administrative expense claim. So we have a few minutes left, and we've had a few questions come in. I apologize I didn't answer these earlier, but let's ask these for the benefit of folks. The first question that came in is, subject to the order allowing, how often will the receiver sell the business as a going concern versus liquidation of the assets? It's a really good question. My experience has been it tended to be more the sale of the assets more on a piecemeal basis as opposed to as a going concern. Bob, do you have any other experience in that regard?
Vast majority of the time, it's asset by asset. Occasionally, you get lucky. I did in one case and found a strategic buyer that wanted the whole enterprise. That worked out great. Very rare.
Yeah, pretty rare. And I think that's probably, you're really looking at more of the piecemeal liquidation. And why would you do that? The idea here is that maybe the receiver can get better value doing it that way. Especially, I'll give you an example, like Kansas. If you have ag land, you're going to have this right of redemption that's not going to be able to be waived. And maybe it's quicker than going through a protracted judicial foreclosure process to get a receiver appointed and just sell the property. So that would be a situation there. Another question that came in, it says the U.S. Small Business Administration generally does not approve the appointment of a receiver. Have you had success convincing the SBA that a receiver is appropriate? My response to that is no. I personally haven't. Bob, have you ever dealt with the SBA and been able to convince them to appoint a receiver?
Absolutely not.
Yeah, I think that's the answer there. And as I'm sitting here, I can't think of any situation, I should say, where I can think of where that's occurred. So obviously, if you're dealing with the SBA loan, the receivership option may really be just off the table. Final question, Bob.
That may be where the monitor comes in. The SBA may be willing to go along with a monitor, but the SBA's main role is to get the government's money back. And anything that gets in the way of their path to that is going to be objected to.
Yep. Final question, Bob, was what does the Form 56 consist of? That's the IRS form. You want to touch on that briefly, and then we can wrap this up?
Yep, Form 56 deals with the definitions of who, what is or isn't a fiduciary. It's the form that implements Rule 6336, as I recall, but it tells you what, if you do this, you are a fiduciary, and if you are a fiduciary, your responsibilities include these other things. Don't make light of it. It's very important.
All right. Well, Bob, I appreciate you being here with me today, and to all our attendees, we really appreciate you participating and listening. As we indicated before, this has been approved for continuing legal education credit. You'll see the CEU icon at the bottom. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with the recording of the webcast and sharing. We do ask again, if you don't mind, before you leave or when you end here, there will be this short survey at the very end. We really appreciate any feedback that you have. If you have any additional questions, or if you'd like either Bob or myself to follow up with you on a one-on-one basis and answer any just questions off the cuff, we're more than happy to do that. So thank you for being with us today, and this concludes our webinar. Thank you.
Thank you.